Good morning, everyone. I'm calling to order this meeting of the Cleveland Heights City Council Housing and Building Committee at 11:02 a.m. Clerk Ballister, if you wouldn't mind, could you call the roll?
Hedges.
Here.
Maddox.
Here.
Larson. Here. Duda.
Here.
Great. Thank you so much. So since our last meeting, I know that staff members have spent a lot of time continuing to work on the legislation. Did everyone get the documents that Director Hanna passed along? So I guess, Director Hanna, would it be okay if you were to walk through some of the changes that have been made since we last got together?
I was actually going to ask if the planning director wanted to do that. I'm agnostic as to who leads it, but I think, planning is helping to manage this process.
And obviously we have Alan and Nuar from the building side of things, because from the housing side of things, because ultimately it's their shop that's going to be administering and enforcing this. So I can walk us through some of the changes that we've made, some that we're suggesting, and then some of the bigger discussion items that we want you guys to weigh in on.
And if I could, so there were two documents attached to the email. Which of the two should we look at?
I think the red line version is probably
Yeah, I agree.
and this is
For discussion
again,
purposes.
This is a version that has accepted the previous differences from what we think is the original legislation and sort of
Which one?
from this is going off of essentially the version that was before council most recently, not the first version that originally was before council.
And I take responsibility for making this confusing, but as I was looking at the red line last night, which has sort of the running comments, which I think are useful for discussion purposes, I thought council may also want to see, what does this look like if most of the illustrated changes are applied? And that's what the second document is, which is just sort of cleaner.
Yeah.
The first one is the red line.
Yeah.
What I'm saying.
Yeah.
First attachment.
And that's what we're looking at now.
Because we can point out better what the changes are.
So just for clarification, one of the two documents has some text in blue underlined on the first page. Are we looking at the other document? Is that what I'm hearing? The one that does not have the blue text on the first page?
No, I believe we're looking.
That's the one. The one with the blue.
Okay.
Yes. So if you look, and we did add page numbers to make this easier to. So if you look on page 1, this is a pretty simple one. There was a whereas that was added, suggested to be added, because one of the real intent of this is that we don't currently track this, and that's one of the reasons that we want it. So that's a pretty straightforward one. If you move to page 2, you'll see in here one of the things that we want to take a closer look at. This is going to be under 76901 definitions operator, what the definition of operator is, and how that conflicts or works with owner elsewhere in the document. We just haven't gotten all the way through that review, but we want to make sure that these defined terms are really specifically used in the right way. Our first sort of significant thing that we wanted to talk to you about is under E, short-term rental. So the original proposal was that a short-term rental is any residential dwelling unit or part thereof. And if you remember last time we spoke a little bit about that part thereof, what that might mean. We're making a suggestion here that any residential unit, whether it's an owner-occupied or a rental property, would be eligible for short-term rental. But the part thereof part of that would only apply in owner-occupied short-term rental. And that's because there's that additional sort of on-site oversight that we feel would be a concern if there's an out-of-town person managing or maybe not even managing the property. So that part thereof could be not only a bedroom, but could be a couch, a bed, a corner.
Or and even maybe not out of town, but not on site.
Not on site.
Not living at the property.
So we know that's a sort of a significant change from what was originally proposed. And you'll see there's some more details about that later on in different parts of
This sorry, this, I know, I don't mean to interrupt your question, but this also sort of built on the distinction that the council president identified in terms of like lengths of rentals. And we, I think, collectively felt that it was reasonable and rational to assume that an owner-occupied rental might be situated differently than a non-owner-occupied rental and be more closely managed and watched. And so that builds off that same theory.
Yes,
So do you want to discuss these as we go, or do you want to just blow through them and then?
I mean, I think that it sort of makes sense for us to go through unless there's a different approach that you think would be better.
Well, then I'm going to need to take notes as we go because I'm not going to remember this.
Or, do you mean questions?
Well,
That you
questions and clarifications, yeah.
No, you could certainly bring up
Okay.
questions.
So,
Is that okay?
so a couple of things. First of all, I'm imagining a form that will have a check. This short-term rental is owner-occupied. This short-term rental is not owner-occupied. I think that's an important information for the city to know. Secondly, yes, making this distinction, if we're going to make a distinction between the length of time somebody, because I'm talking about this as the policy, I'm looking at the policy part of this that you put in the notes. That would be a distinction. If we're going to make a different rules for owner occupied as opposed to non-owner owner occupied, you'd want to make this distinction here. So that's two reasons. The last thing is, of the 24 complaints that I got from residents about short-term rentals, 0 of them were owner occupied. I mean, it's part of my rationale, so I'm just throwing that out there. You know, I would have a different take on this if it was like some were owner occupied, some weren't. None of them were owner occupied. So just, that's my 2 cents on this.
Any comments or?
No, it sounds
Yep.
like the council president is supportive of that.
Yep.
Pretty big change. So we will keep that in there for now.
Okay.
Because it doesn't seem like there's any opposition to that. And I'm not going through every change that we're making here because I think most of them are sort of self-explanatory. The next comment is part of this is sort of what the council president was saying is some of this is going to be codified, but a lot of it is going to be based upon the form or the application. And so one of the things we would require as part of that application/registration is that there's a notarized affidavit. This is what Dublin does, is you put the onus on the person who's applying to say, for example, yes, this is an owner-occupied property, et cetera, et cetera. So we will, those will be part of the ways that we are ensuring that we're reviewing this by putting some of those onuses upon the applicant.
How would that be done? Can that be done right here when they, the notary? I mean,
Can it be done right here, meaning?
Is there a notary on site here?
Sometimes, but I mean, we may be able to provide a notary, but I'm not sure we would be in a position
There
to
are other
guarantee it. They can go to a bank.
Yeah, there are other examples of applications we have where it's required to be notarized.
Yeah, I just want it to be easy for people, I guess.
And I think that's the tension between like a certification, which says, I agree that everything I'm telling you is true. And an affidavit, which has a notarized, carries a little bit more weight. But in either case, we want to make sure that everything that they're representing, owner occupied status, et cetera, is true and accurate.
So you'll see the next addition is that owner occupied short-term rental. Adding that as a term because if we're going to now regulate it differently, it needs to be a defined term, and that goes to the 270-day cycle, which is something that made sense to us. You'll see here we have a little bit of commentary on transient guest and making a suggested change there. I'll take some of the blame for this one. To me, that term transient just didn't seem right.
Although it's often used in other
Absolutely.
short-term rental
I think it's an open,
Yeah.
an open item for us, but yeah.
But we took the authority here to at least make the suggested change, so we're changing that to short-term rental guest. And you'll see here that one of the things we want to review more closely, and I think Bill's noted says it best, is that in Dublin's ordinance, this transient or short-term rental guest is the person renting as opposed to the person as it's currently defined who's entering the agreement.
Right.
Because ultimately, those are two very different roles that people are playing.
Could be.
Could be.
Right, but if we only define the person who's signing the rental, we're not necessarily capturing everybody. Whereas if we have another broader definition, which could be different than what Dublin did, then the person renting would also be a transient guest, but they would in addition have this special status as
Right.
Yeah.
signing up.
So there's a little more work to do on that one, but that's sort of where we're at.
So you're thinking like it could be a gift, like I'm gonna buy you an Airbnb, like somebody's not going on the trip, right? But they're,
Yeah, we were thinking along similar lines, if my father, for example, is the one who booked it or was entered the
Yeah.
contract, but I'm actually staying there.
yeah,
We want to make sure that the person who's causing the concern is the one who's actually being dealt with properly. You'll see in section 76902, some of the, it's just not structured properly, so we just have to come back to that one and redo it a little bit better. We did want to make sure in the next section, which is 03.
Eric, can I stop you?
Yeah.
I'm sorry. Give me just one moment. 76902 is actually, I renumbered these when I went through sort of the final pass, because these were previously subsumed within 76901, and to the planning and zoning director's point, they didn't really fit. So this is now a separate section that applies to applicability. And I think all the renumbering is done there from there, but it is now separate,
Yes. So again, we just want to review
finding the
that.
scope of the chapter, yeah.
Yep. The next section, which are the registration requirements, there's a couple notes here we wanted to talk about.
I'm sorry. Let me back up just a second. So this particular section, 769.02B, mentions a short-term rental excise tax. But you've written it, Director Hannah, so that it says with any local tax requirements applicable. So that means if we don't do the excise tax to begin with, but decided down the road we could do that, it would apply.
Yeah, I mean, we would just update this language depending upon which way the city goes with that issue.
All
And
right,
that's one of the things we want to talk about when we get to that section.
Mhm.
thank you.
But yeah, this, I think, as the law director said, is written in a way that whatever taxes currently exist would be applicable, and then doesn't preclude us from making that change in the future.
Thank you.
76903 is a pretty important section. Those are the requirements themselves. You'll see in here, we just call out specifically that there would be a fee with this, whether it's the registration or the renewal fee. Some of the things that we'll want to make sure are included is about the out-of-county or vacant registrations, like in our other parts of the code, are that this language reflects that. And then we wanted to make sure that there was some discretion in here, and you'll see it's the mayor. Well, actually, there's another section. It's mayor, administrator, or other mayoral designee. We had a lot of back and forth about who should be the person that ultimately is making the final call on this. But that type of language allows it to be the mayor, it could be the city administrator, it could be really any one of us sitting at this table, and that could change with time. So it doesn't have to be, I know in other parts of our code, we say something like the building commissioner or the director of planning, and that sometimes can be too limiting. One of the things we want to talk to you about, this is next note on here, policy discussion, is how we deal with people who have short-term rentals today. And, you know, so this law goes into effect, you know, you adopt it on such and such a date. We now have a pretty lengthy process for people to go through. You can't imagine that you would want all of those places to shut down until they go through the process. And so one of the discussions we had is, just like we did with the Lead Safe ordinance, we could say, hey, we've adopted it on this date, it doesn't really become effective until this date. Or we could actually put into here some language that says, you know, people have a 6-month grace period. So we really wanted to leave that up to you if it was better done in a codified way or in a sort of legislative public policy way at the time of adoption. Bill, you think I captured that well?
Yes.
No, go ahead.
And are you like asking for a preference on what we would like there?
Yeah.
Okay. For the author, do you happen to have a preference?
Well, you know, and I had talked to Director Butler about this. You know, we need time to create, they need time to create a document, you know, a form, and then we talked about doing a rollout, public, you know, information rollout. And, you know, I was thinking several months, but what's the alternative?
So the alternative is to actually put in here a grace period
For compliance.
yeah, so any short-term rental that was operating prior to the enactment of this legislation would have 6 months, 10 months, 12, whatever it is to comply. You can be very formal in doing that, or you can do it in a more informal way, like I think you were describing.
Or alternatively, it could be just a hard and fast date that's fixed here, so we don't have to measure from June 11th or whatever to.
So that's when we could just say the law takes effect on such and such a date and put it out in the future enough to give people an opportunity.
Or it could take effect, but then have a sort of a built-in established grace period, as the director said, for
I
coming
would
into
be in favor of
compliance.
that.
Yeah.
I think regardless of which mechanism we use, I think that I would be partial to something that's at least 6 months into the future so that we have enough time to educate people.
I would agree with that. I think 6 months is a good,
Six
I think a
or
year's
nine.
too long.
Yeah, maybe a year is too long.
But, you know, 6 months I think would be reasonable and, you know, lengthy enough. Anybody else?
Councilman Maddox, do you happen to have a preference on this point?
I think it's 12 months.
I think 12.
Just to disagree based on what adjustments they may have to make or what's in their budget or what's moving around, at least 9. I just think there's gonna be some time. 6 months, if they have to make some type of investment in order to bring this up to standards or anything, I don't know in terms of someone's budgets, I'm just thinking from that.
Director Zamp, what about like with regard to other programs? Do we have this sort of like mechanism in other programs? And if we do we have 6-month delays, year delays? Or if we don't, do you happen to have a suggestion for how we handle this?
I think Lead Safe is the good example. That was a 12-month implementation period, which
Was necessary.
was necessary, and that was built in to the code itself.
Okay.
See, my thought is, this isn't, I mean, they're already running this business, you know? It's not a new business, you know, in that sense. So I don't know that it needs what Lead Safe is, which is we had nothing like that in place, and now we have something in place. This is just changing the form. I mean, well, we haven't decided exactly what's gonna be changed yet, but if, you know, just running off of this model as or this draft, you know, I don't know. I think 6 months is plenty.
Councilwoman Lawrence, do you have a preference?
I would go 9 months. I would go out 9 months because there may be some adaptations which Councilor Maddox is including in his statement that somebody is not necessarily in compliance with building codes for doing this particular activity. And maybe they need to bring their infrastructure up to snuff, so yeah, I I would go 9.
So while there are different opinions, it seems like 9 is about the consensus. Is that
Yes.
okay?
Mr. Chairman?
Yep.
I would just point out for purposes of discussion that the alternative is somebody who isn't in compliance could stop renting their property out temporarily until they achieve compliance, rather than continue and then be, cited by the city.
So do you bring that up to suggest 6 months or?
I bring it up to make your job harder. But just throwing it out there as, there's different ways that this could play out. And I think Councilman Maddox's comments are thoughtful and that's appropriate to take that into consideration. On the other hand, the city has an interest in moving forward with something along these lines, and it's taking some time, obviously, already, so that when council, as a whole gets there, I think you would just want to have a full discussion that includes all those considerations.
Okay, so
On the compliance side, I would hope that nobody's gonna get a certificate of occupancy whose property is not compliant, I really would like to see the city enforcing that rule and that not be something that's specific to this particular legislation. But we just should not be giving certificate of occupancies to people who are out of compliance. I mean, if we never do this, that shouldn't be something that happens, I understand what you're talking about, what if, but, my answer is they should be compliant with the codes anyway and not be getting certificates of occupancy for rentals if they're out of compliance.
So do we want to leave this as an open point for discussion now that we've heard each other's thoughts? Maybe between now and the next meeting, we could think on it more and then plan to make a final decision at the next
Well,
meeting.
If the consensus is 9 months, then go with it.
Got a question about something. How often do you have to go back for a certificate of occupancy?
Annually.
Annually, correct? So that does leave an issue for me, because it is possible that you could have a tenant in a building that is no longer up to snuff, and that occupancy has to be removed. And the reason I'm stating this is because it's happened several times in the wintertime. So you have somebody who may not have a place to go, but there may be a minor issue with that property, but minor enough that they could stay there, but maybe wouldn't meet those standards. I guess, what do we do in a case like that? I guess is my question, because in the past, it's been very iffy. You could end up in a situation where you have to remove somebody from a house because it's not in compliance. At the same time, it may not have any place to go, but if it's been previously in compliance, there could be a tenant in there already. I was just in my head already because it's happened a couple of times. So that's the only thing I would.
Well, this is why I think it is a complicated discussion, but I also wanted to suggest that my guess is there's a lot of Airbnb or other brand name short-term rentals taking place that are in single-family homes that aren't getting an annual certificate of occupancy. Like, it's just not an issue because they're not considering it as a rental use in the same way that a home that's just offered out for long-term rental is.
I mean, I understand the concern about that for long-term renters, and that has come up in housing court several times. But in this case, just for the purposes of the discussion about this, I don't see as how it would be relevant, because, I mean, although it would stop a stream of income for somebody who's doing short-term rentals. I mean, we're either gonna enforce, we're either gonna give certificates of occupancy for dwellings that are, up to code or not. I mean, and nobody's gonna get kicked out in the cold because of this for short-term rentals. If you're just asking a broader question about how this would work, it's worthy of discussion, but I don't know that it applies to this particular ordinance.
Mr. Chair, if it's
Yeah.
okay, so a little bit later on, we have our section on sort of the inspections and enforcement part of this. I think we'll be able to talk through that better over there. But right now, we're just talking about, this is really a one-time issue that we're dealing with. Is we've got existing short-term rentals. How are we going to treat them in the short-term, but, as this legislation comes online. So I think I would suggest that maybe what we can do, and we'll talk about this at the end, is we can provide a draft that has a 9-month codified grace period
Okay.
in there,
Great.
and then that'll be up for discussion, whether it's at the committee level or at the council level ultimately.
Because it is a one-time, implementation's gonna take some time, educating people is gonna take some time, so, well, I would like to consider that as we look at what is the grace period.
And just coming from the Lead Safe point of view, it's been a lot of work we've had to do in the background.
Yep.
So, we can come back to that.
Okay.
Next go around. You'll see the next section is the registration itself. This is mostly gonna be focused on essentially giving the administration the ability to come up with a form or application that asks a whole bunch of things. But you can see here, it has some information that's gonna be required, including basic information about the property, the hosting platforms themselves, the person who's owning / operating the rental, and then some certifications like we spoke about earlier. This list was pretty long and we spoke for some time about it. These are things that the average person is not gonna have any time to really review. But we do have to have some assurances that people are gonna be abiding by our laws, and so that's why they're listed here. And a person is just certifying that they recognize that these are things that will apply to them. Number 5 in this section is that the operator, i.e. the property, is current on tax and utility payments. It does say here, including that excise tax, because that's, again, sort of up for debate right now. Acknowledgement with all federal, state, and local laws, acknowledgement of the Fair Housing Act, and then 2 new ones that we added. We want to hear from them how many units they are, because if we don't know that number, then we will have a hard time enforcing it. If we just leave it up to what we think is in there, and then we come along and it turns out there's more or less, that'll be hard to enforce. But if they say on their application, we're gonna have 4 short-term rentals in here, and we come in there are 5, there's a problem. But if there are 4, and that's what they disclosed in this application, then that would be sufficient.
So what if it's a unit with 2 long-term rentals and 2 short-term rentals? Because I actually know of one.
This application, or these questions would be on the short-term rental component of that.
So they just have to disclose that there's 2 short-term.
Yeah, we would
rentals.
know, we should know already through our
Yeah.
regular rental registration process about the other two.
Well, I would assume that they just have that they have 4 rental units. Because the landlord is not making a distinction between that at the present time.
Sure.
So they'd be filling out 2 separate forms. This is the question. They'd be filling out 2 separate forms, one saying that they have 2 long-term rentals, I don't know if that's what we're gonna call them, and 2 short-term rentals,
Essentially.
and 2 separate.
Whether that's a different section of a form or.
Yeah, okay.
Mr. Chairman, if this also might be a time to look at adding here what the council president suggested earlier, that the form specifically include an area to indicate owner occupied status. I don't think that's in here yet. I was just trying to look again. But it would be a good thing just to call out so that as the administration develops the form, we know. what's one of the
Box to
things.
check,
So for clarification, would this require a separate form for each property? Or one form for all properties and then you would list each property there?
It would be by property, but if there were multiple units.
Within it,
property,
one
it would be
form.
one form, yeah. And like we said, we don't know yet if it's a section of an existing form that we already have or a separate form altogether.
Okay.
But we want that flexibility to be able to figure it out. The last addition here is a really important one. because we know that parking is probably going to be, parking and noise are gonna be the two biggest issues / concerns. And we have some debate here, I think, about what we want to require in the application. As we're proposing, as it's drafted, is we're asking for them to sort of explain how parking will be managed. And that there's a statement in here that impact should be minimized to the extent possible. The question really is, do we want to develop a very specific parking standard for a short-term rental? Or do we want to, similar to number 8, have them say that only 2 cars will be parked in the driveway or in the garage, and whatever that is, if they're not complying with it, then they can be cited for that.
And this is part of the internal debate we've had. I tend to think that from the enforcement and fairness standpoint, the city's going to be in a position to more easily demonstrate fairness when it goes to enforce if we have an objective standard. Inviting people to say, here's our plan, makes it hard for us later to go back and say, are they or are they not complying with this? Dublin's ordinance, for example, I think it does make a reference to the number of guests, but it also says the number of vehicles that can be garaged, and then 2 in the driveway, and then it says in addition 2 on the street. Now in Cleveland Heights, that's an issue because of our overnight parking ban.
Mm-hmm.
But it's very clear and easy to look at that, and if you see more than 2 cars in the driveway or more than 2 on the street that are clearly associated with the property, there's some prima facie suggestion that there's non-compliance. If we ask each property for a plan, it's just more difficult. But which is not to say that that's not something that the council should consider, but that's just the law department's perspective on it.
And I do want to add that you may be asking the question, well, why are we making this distinction here between a short-term rental and a long-term rental? And the idea there is that if a long-term renter parks on the street overnight, they get a ticket.
Right.
And they're probably not going to do that.
They're not gonna know,
No,
probably,
But
right?
well, I think that
Somebody's out
probably
of town, they're coming here.
if this goes forward, I think that the posting that it contemplates being made inside the house will advise people about the overnight parking ban.
Yeah.
But nevertheless, not every renter or guest is going to read that.
But Director Zamp, as you were saying, so if someone is a long-term renter, they're not going to make that mistake, but
They will make it twice.
yeah.
Yeah.
With the short-term renter,
Yeah.
well, it may only be one night. And so if we have 5 different short-term renters during a week, then now we've created maybe an everyday problem.
Right.
I'm not sure if it's a standard that is required when you go to post on Airbnb, but for the most part, most listings will say that there's X number of off-street parking for this particular rental, or there is on-street parking available, or there's not on-street parking available. So if those people decide not to read the full listing when they book, I mean,
I think it's
Like
dependent
centrally.
upon the property owner
well, correct,
accurately listing that.
correct. Although I'm not sure if that's a requirement of the posting. Like if the Airbnb website or Vrbo or whatever we're talking about, brand name, requires them to say in their listing how many before they're able to post. I'm not sure if that's true or not.
So for clarification, are you asking for our preference on whether, which of those 2 we'd like?
Yeah, I think we want maybe some input on that, because as you heard, there's a little bit of internal debate on it, so having some guidance would be great.
So I guess if you, from my perspective, it seems like just look at all the different parking options. So on street, never allowed. So, but if you have a garage, then that ought to be allowed. And if you have a driveway, as many cars as you can fit into it before they, flow onto the street, it seems like that ought to be allowed as well. It's problematic whenever someone is parking in someone else's property or on the street. Those are the cases where it would be or on the front lawn. So if we were to say as many spaces would be available in a garage or on a driveway, it seems like that's the way to define what would avoid issues.
And that might also allow a standard that's objective but isn't tied to a specific number. If we ask people how many spaces are available off-street without blocking the sidewalk, for example.
Yeah.
Unpaved parking surfaces.
So I would see how an owner occupied short-term rental where there's, assuming, they'd have cars and, now they're gonna have more cars, I don't know what you do there, cause do you give them some accommodation beyond what they would ordinarily have, because that's like, you're essentially doubling, you could easily be doubling the number of people in the house for that period of time, period of the rental, and doubling the number of cars. I don't know if people usually bring one car with them.
But regardless, I think that they would be limited to however many spaces are available in the garage and in the driveway. And if we don't specify a specific number, because some driveways are longer than others, then you just say, however many can fit in those two places.
Is this gonna be part of the form that they fill out? What's your parking plan, or,
Well, I think that's the
what we're
question.
debating.
Which of these two do we want? Do we want them to specify a parking plan, or do we want to tell them what the rule is? And
Yeah, and as I've said, that would be my preference, but I do think it should be on the form, whatever it is, so that, the city's evaluation, thinking about the people in your department who are gonna be reviewing these when they come in also, is gonna be also easier if there's a rule rather than, subjective evaluation of, does this plan make sense? And I think it's also worth council asking itself, what would a plan look like if it doesn't involve off-street parking on property? And with regard to the point that you made about an accommodation for owner-occupied units, I think that's up to them, is the way I would look at it, that to the chairman's point, if they have two cars and they can stack them in a way that allows them to get in and out to their, comfort level and continue to rent out part of their property, great.
up to the host.
Yeah.
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 And then another disadvantage that I see of having them specify a parking plan is what if they say okay, part of my parking plan is to park on the grass. And so I'm assuming that that's not allowed in our city. So then the staff is going to have to judge, whether the parking plans are allowed. So if we just specify that cars can be allowed in the garage or driveway up to the point where they don't spill into someone else's driveway or on the street, that seems like the way.
Right, because shared driveways are another concern.
We have a couple of those.
Yeah,
I would like to say that it makes sense to me for two reasons. Number one, that if you have it on the form or you have, and in the codified legislation, that this is what the city requires. You can't park on the street at night for the whole time, and you can't park on the grass, and you can't park in a sidewalk area. Then those people, when they see the application, it clicks in them, that host sees, I remember those, but I need to think about that when I advertise that particular unit. The other part of it is for the neighborhood. If the neighbors know that these are the constraints that have been already discussed with the host, and they need to follow those constraints, and that gives them some opportunity to say, hey, your parking plan's not working, or whatever, however you negotiate that. And I also feel like the staff should not have to be making judgments out. That just becomes more difficult too, so we need to give some, pardon the expression, concrete guidelines.
Councilman Maddox, do you have a preference here? So, yeah, I think the consensus sounds like we'd like a defined standard that is along the lines of what we just discussed.
Yes,
Okay.
that'd be clear. Just last subsection of this section, you'll see that we make a suggested change to the registration just aligns annually with our rental registration, so that we're not, once you start having a 3-year period, then it just becomes impossible to track. So let's just have everybody do this every year.
Yeah.
And go forward with that, make it simple. Standard conditions is the next section. These are basic things that we're asking each of these short-term rentals to have. We want to know when there's a sort of a new registration. There's a 30-day period in here, but also should it be upon request? And this is a little bit different than with a long-term short-term rental where we typically ask for, hey, if the renter is changing, we wanna know when that's happening. Obviously, in this case, that would become just overwhelming. So it's really more about, this is section 76905A. So if there's a change, whether that's adding a new unit or changing a condition, we want to know about that within 30 days. Or if we think something's up, then we can do that upon request. That's just a simple change that we had. I don't think there's anything else here. Most of this is the same. In the next section, this is the renewal. We wanted to just make sure that this aligned similarly with our rental registration renewals. And things being prorated, so if you started out in the middle of year one, the renewal, the fees are based upon sort of standardizing that across an annual period, not just when you did it.
If I could, so back to the last subsection of the previous section about liability insurance. So I remember that we briefly talked about that during the last meeting. And so I guess, am I understanding this language here? Do most of these platforms typically offer $500,000 of coverage? And we're saying that if they do, then that's sufficient here. Otherwise, you have to demonstrate that you do have that coverage.
Yeah, and we probably should have had another thing here. We want to double check on this again.
Okay.
And there was some materials that the law directors sent around recently that talk to this, but that's our understanding.
Okay, question, so based on this language that's here, so it says insurance provided by hosting platforms may be used to satisfy this requirement. So let's say that the coverage that's provided is for $100,000. Are we saying that that could be sufficient for this $500,000 requirement?
I think the answer is no.
Okay,
Yeah, we want it to be the 500,000.
so it has to be comparable,
But
okay.
but being supplied by or
Yeah,
made available
okay.
through that platform would be okay as long as it meets,
Okay.
criteria.
Did we have a, I'm sorry, did we have a discussion about this being an undue burden on the?
I think we may have briefly mentioned that at the last meeting. I think we might have had a conversation about it just because of my past housing. But
To enforce the insurance.
yeah, I guess my position would be that that's pretty typical, but
To have it,
to have it.
okay. Did anybody, I'm sorry, I have some vague recollection of somebody saying, oh my God, this would be a terrible burden on
We spoke about it.
on the department to track it.
Yeah, I think that was before we had some more comfort about the hosting platform insurance.
Okay,
But again, we want to double check on that and make sure that if
Right.
9 out of 10 times it's going to be fine, then that's not an undue burden. If 1 out of 10 times it's going to be fine, then it's a different story.
Would this be one of the other things that they would be certifying on the form, that we certify that we have this coverage, or do they need to,
They're going to have to provide
Provide proof.
proof.
and then we would like photocopy it, for example?
Yeah, and then we do this similarly.
Yeah, they would upload a document, or the hosting platform would supply all the list of their people, the properties, and with that, they would say, hey, we also have insurance provided for all of these.
Okay,
And I think we would want like a certification of all the representations in the form.
Going to 76907, this is denial of an application, right? So this is where we start to get people who may not be happy with the decision that we make. So there's a process here, and there are very clear ways in which the administration can deny an application, which are listed here. We want to just make sure it lines up with another part of our code, so that's just one thing we need to look at a little bit better. And then
can you appeal that? I mean, there is an appeal process?
Yeah, it appears a little bit later, but
Okay, I didn't know.
the director's point, we're having ongoing discussion about sort of the best way to set that up and the best sort of board to point to. We have a couple of existing boards in the code for different purposes, and we have an ongoing dialogue about which one would make the most sense here. I think our feeling collectively is that it doesn't make sense to create an all-new board, even though it may have an all-new name, but sort of to use one of the existing templates.
And this section culls a lot from the ORC and also our existing code. So we're really not trying to add any new criteria to a short-term rental, but just that the mayor or their designee can be rejected because they're not following state or local laws. So for example, in subsection 8, the short-term rental premises have been declared a chronic nuisance pursuant to Chapter 553. That's not really a term we use, so it's just something we want to go back and see if there's a better way to define what that is trying to accomplish. The next section, which is section 76908, is avoidance of nuisances. So this is where we're gonna, in this section, define what becomes I wanna get the right, rebutable presumption that the property now has become a nuisance. And so right now, we still wanna just double check that this is not conflicting with what we say later on in section 76912, but also chapter 553. And then one of the things we've been talking about in this first paragraph is the way it's written. For the purpose of this section, 3 or more written citation or notices of violation for 1 or more of the following behaviors within a year creates that rebuttable presumption. That's not necessarily the time frame and number of violations that we use elsewhere in the code. And Alan can speak a little bit better to this, what we do in other parts of our code.
Yeah, so chapter 553 says it's 2 within a 6-month period. And again, they specify which of the general offense codes that are, you can have 1 on a certain, if it's a more serious general offense code, or but basically says 2 in a 12-month period.
And part of the discussion we've had is the fact that this has more to do with sort of the validity of the registration and whether some action is taken with regard to the owner's right to use the property in this way, rather than a criminal citation, which is what 553 principally deals with. So I think our thought was that there may nevertheless be benefits to syncing up those numbers. On the other hand, this use is different. You may have lots of different people coming through a property in a year, as we discussed, so that a different standard might still make sense. Right. We haven't gotten to a conclusion.
Depending on the criteria and what level of violation, if any are cited, that you want to use for it, what becomes a nuisance on this versus a regular owner occupied property or any other property per chapter 553.
So you're still working on what you think.
Yeah,
we're
these nuisance related and to some extent denial related, revocation related provisions are all
And
some attention.
one more question before I go to President Kuda. So this is for a specific property, so for a specific registration. So if someone has, let's say, 3 different properties and one is a nuisance, so this is just regarding that particular property and not necessarily all of them. Is that how I should understand this?
Yeah, that's how the section is defined.
So I don't have a problem with defining the number or anything, but I remember having a conversation with you saying it's not a good idea to, I thought you said,
It's a privilege discussion?
not to my knowledge.
Checking, yeah.
Not to my knowledge. But no, as a matter of fact, you gave me a written
Okay.
answer to the question, and I actually read it at one of the housing meetings.
So it's not privilege now, as much
No,
as
not anymore. And you said it's really best to leave this open to the discretion of the police department and the housing department and so forth as to, when we wanna.
Yeah, I think, I'm sorry. I think the question there had to do with discretion and ensuring that we don't create some ability to for the codes to be enforced in a way that disadvantages certain residents versus the need to maintain sufficient discretion that the codes can be properly enforced. And I think Councilman Maddox had some concerns in an early draft of this related to that subject, and that conversation took place in the context of sort of not compromising, but just balancing those interests and trying to get to the right point, which is part of the reason that our internal discussion is continuing on this question.
Yeah, it was just, I also remember that we've had a discussion at this table about trying to have a parallel wording in this legislation that syncs up with what's already in existence. So are you weighing that when you're thinking about this as well?
Yeah, that's what the law director had mentioned, is that we have language in another section that's dealing with something different
Okay,
that this doesn't sync up with, and we're just weighing,
But it sounds similar and so
yeah,
potentially confusing.
right. So should we sync them up, or actually should we not? We just haven't landed on something yet.
thank you.
And what is so different about this that you might not want them to be the same? What is, I mean, about this legislation?
We're not creating a right for somebody to be cited here. We're addressing again their right to use the property
Yeah,
for a certain purpose. The Chapter 553 standards all exist on their own outside of this chapter. It's how we incorporate them and utilize them for purposes of ensuring that this chapter is enforceable and sufficient for the city's purposes. Does that make sense?
I mean, I guess whatever you guys decide seems, I mean, this is above my pay grade with the, to even weigh in on.
So the next section, which is 76909, begins on page 6, but really continues on page 7. We spoke about this at a previous meeting, but we want to just go through it again because it was a pretty big change in subsection B.
Sorry, changed since our last meeting?
Well, I think we define it better
Okay,
than
yep.
last spoke.
This is 09?
Yeah, 09B. And this is a limitation on the number of short-term units that are permitted within a structure or a building. And so we've got some distinctions here, which, again, we spoke about previously, but I don't think we, had the firm language. So just to run through it, multifamily buildings with 4 or fewer dwellings, essentially all of those could be a short-term rental. When they go 5 and above, there's a formula so that means that these larger apartment buildings can have some short-term rental units, but not all of the units could be short-term rentals.
What's the rationale for that?
Well, first of all, that's what many other places have done. That's what this original text was. And I think there does come a point, but these guys can speak better to it, that then you start having what essentially becomes a hotel or a lodging house, because it's just the whole entire building becomes
Constant turnover.
just constant turnover, as opposed to whether it's a smaller structure or a mixed environment. So 3 is owner-occupied single-family and 2-family buildings. There's no limit. As we said earlier, that could be even the part thereof. But the single-family buildings that are for rent, we're saying it's only the unit. The structure itself can be one short-term rental. And then for 2-family buildings that are for rent, that is the equivalent of 2 units. So we're making this distinction, owner-occupied versus non-owner occupied, and limiting the number of units, because again, that's where we think the sort of public concern is.
So let me make what I think is a counter argument to this, only just for discussion. I think part of the problem for long-term renters is when people are coming and going in their building. So I could see somebody using that rationale to say, maybe it's better to have a 12-unit apartment building, all short-term rental, as opposed to the disruptive nature for the long-term renters of having short-term renters coming and going with them. I have heard that argument from people who are in that situation. Just throwing it out there.
Yeah, just sort of as an extension of that, I certainly understand 3, 4, and 5, why we'd want to do what we wrote there. But for 1 and 2 along those lines, some of the things that I've heard were like in buildings with like 4 units, where there are 2 like long-term renters, and then they're, frustrated by the constant, noise from the 2 short-term rentals. I don't know necessarily what the right solution is there. But yeah, I'm not sure that I personally.
And part of that problem is that in the units that I'm thinking about, that people have complained about, it's the people coming in at 3 o'clock in the morning. And I'm sure that there's some kind of regulation about that that's not being enforced, but.
When I rented, I used a broom.
Well, I was gonna say to some extent, I mean, you can't get rid of all of these problems, right? I have neighbors that come in, I mean, there's 5 people that live next to me and they're coming and going all night. They own the place. I mean, I can't do anything about that. Like, there's.
But I think that this, if I could, one more thing and then I'll, so I guess if there is a violation, a nuisance violation, 3 of them, then we potentially could revoke
Right.
their
That would
ability
still-
to use it for this
Right.
purpose. So they would be allowed to have 2 rentals and 2 long-term rentals, but if they were nuisances, then we could revoke their ability to do that. Councilman?
I just want to also keep in mind, there are 1,000 reasons why someone coming into Cleveland could be coming into their house at 2 or 3 in the morning. A flight alone could shift someone's entire travel schedule. So just keep that in mind too. You really can't get upset at someone for coming in with luggage at 3 a.m. if they were in an airport for 12 hours. So there's some extenuating circumstances, I think, for some of this feedback. But again, to Addie's point, I don't think you can please everybody with that. Just based on the fact that some life's going to happen. Especially if you're traveling, life is going to life. So I think that's going to have a huge impact on some things.
I think that, quiet enjoyment is something that everyone, has the right to. And so if you rent a space with the expectation that your sleep is not going to be disrupted every night, and then it turns out that it is unexpectedly, then, that is the sort of like situations that I've heard about where, there are long-term tenants who are being constantly disrupted by new guests coming in. This, I guess, creates that regimen that would enable that use to be revoked.
And I was just gonna throw out there as well, and I agree with that, that, you could get to a point where we're trying to make a decision about either every multiple dwelling unit building would either have to be all short terms, which looks like a hotel, or no short terms, if you're gonna really resolve that problem. And I think that the better balance might be having appropriate standards for addressing somebody who's not operating their short-term rental in an appropriate way.
I think that I personally now understand the rationale behind 1 and 2 and am comfortable with those.
And we certainly can revisit this as the first year goes by, and say, oh, all of our complaints were in these mixed-use buildings, so maybe we need to revisit it.
Just being reminded that the whole purpose of this is to specify that, if you fill this out, then you can use your property for this purpose. But if there are continual issues, then that's at risk.
Right.
And so that allays my fears about 1 and 2. Right.
Yeah, we had concerns about how they figured it out, and just talking through it kind of helps you understand some of the problems that you may come up with. Either it's all or none, or why we're singling out multis. As we're looking through it, a thought came to me about the 2 families as well. A lot of the 2 families that are in the city have a 3rd floor that's a separate rental. And even if they're not an owner occupied 2-family, that 3rd floor actually is a unit that I've seen rented out on these platforms before. So if we're only saying they can only do 2, we have to monitor that 3rd floor. Is that something you want to change to say, or portion thereof?
That's a good point. Should we?
So I think we kept it simple. So far, where we said the owner occupied 1 and 2s can use the part thereof, but the non-owner occupied ones are limited to these
Just the number of legal dwelling units?
Yeah, and I know that we have a handful of legal 3s. I mean, it's literally.
I was gonna say, we might look at changing that 1 per rental unit or dwelling unit reference to address those.
Yeah, I think we can try to address these handful of legal threes, but the ones that are renting out their attic, then that's an illegal unit. Obviously, we don't wanna allow that to continue.
Modify
Yeah.
a legal unit. Okay.
The bottom two portions here, you'll see this is E and F. This is sort of defining the length of time that people can rent out these units. And just the last section there. No property may be rented out for a short-term rental for more than 29 days in each consecutive 2-month period. We just found that to be a standard that was gonna be really, really hard to enforce, so rather it's a short-term rental.
We gave F and F.
Yeah,
You what?
We gave F and F.
Definitely.
But I think, yeah, the discussion largely was that this is very hard to monitor and to track. So,
and just so you know, this is Kareem, he's a high school student who's sort of interning with
Oh,
us.
cool.
So,
Welcome.
From what school?
Cleveland Heights.
Nice.
A couple of questions. I got a question about subletting and how that could possibly impact this if someone was going away for 30 days or so, if that would have any impact. This legislation would prevent them because apparently a lot of them are using these platforms to sublease them for 2 or 3 months out while they're on summer vacation or something like that. So I wanted to know what type of impact something like that would happen. And then I have another question, and this has actually just happened. About a week ago, a pastor came in town with his wife and 3 kids, and they stayed in an Airbnb. They came in on Thursday night. They stayed Friday, Saturday, and Sunday. He was installed into a fellowship and they left. He used the Airbnb. Am I reading this properly in that he wouldn't have been able to do this with this legislation because the rental was too short? Is that right? The amount of days they stayed? Am I reading that right?
somebody could rent it for longer than they occupy it, I suppose.
Right, because awesome, you're saying.
Which would, market conditions then would say that's probably not where they wanna rent, but.
Okay.
And again, we made a distinction in E that the owner occupied units
Right.
get a little more,
More.
they can go from 1 to 6 days.
So if there's no owner there and they're renting it out, the limit is 7,
Not
the-
less than 7, no.
The owner's not
not less than 7.
occupying.
Yes.
Okay, so then he wouldn't have been able to do what he did because it wasn't owner occupied.
Okay, yeah, well,
Okay, so this
unless they rented it for 30 days and.
right. So this would stop essentially any weekend Airbnb rentals in the city, right?
For non-owner occupied.
Occupied.
So is that a change that we wanna make? Like, what's the rationale for discontinuing that?
It's this distinction that we've pretty much started this conversation with of the owner occupied units versus the non.
Non-owner occupied?
Yeah.
Is that, so I guess, is that a change that you're recommending that we make?
Yep, it's in our text here, so.
Last one.
I'm not sure I understand your question.
You're saying that it should be 1 to 29 days regardless, right?
No,
No,
we're
no.
making a distinction. An owner occupied short-term rental could be
1 to 29.
Right,
But if the owner does not live there,
correct.
it can not be less than 7.
7
Yeah.
to 20.
And that's, which was
Which is
your
what
initial,
And
suggestion.
that's going back, that's my concern, that kills a major part of these businesses because even I don't rent for 7 days. When I'm out of town, I may stop in for a weekend, I think maybe Thursday through a Sunday, but a lot of these are turning over on the weekends because you're visiting family or there's an event and you're leaving. So that's my concern. I know you're gonna get major pushback from that.
I think if I could add one thing to that, so I think that I am partial to what you described. And we still have the ability, if something presents itself as a nuisance, then we could revoke their ability to use the property for that purpose. So if there are people who are, only renting for 3 days at a time and it's not an issue, then it's not an issue. But then if it is an issue, then we have the ability to tell them, you can't use your property for that use.
Can't say I've ever rented an Airbnb less than or for more than 7
Director
days
Zanf,
at
how
a
do you feel
time.
about that? I know that that's not what you suggested,
Maybe we
but
did.
No, I don't think we felt strongly about it.
Yeah, I think that's right.
So standardizing this, that essentially a short-term rental could
And
be up to 30 days.
there are communities out there that have much more severe limits. Some prohibitions, some, I think, again, Dublin is 2 weeks in a year and 14
for
days.
each calendar year or something.
Yeah. So we're much more permissive than that. And I think, I just wanted to mention to the point of subletting, I think that might be worth some further consideration in terms of terms and conditions that we would want to utilize. But it does, in section 76904B3, it talks about the registration, including a certification from the owner or tenant that they have the right and authority to do this. So if the landlord is okay with the tenant subletting on this basis, this ordinance wouldn't stop it.
Okay.
And that has to be in a lease that you could sublet it. You can't just do that.
Correct. And I think that's something we would want to require evidence of just to.
And in the case of what Councilman Maddox is talking about, that's still month to month. I mean, I don't know. I guess I should ask Director Butler, but it seems like a month to month rental, not necessarily, what is defined here as a short-term rental. Oh, did I lose?
And did we conclude the discussion of subsection F? Okay.
Well, you have,
No.
Yeah,
What-
but I was thinking more of F, just.
So let me just add a couple of things about this. I mean, the reason why I came up with this restriction in the first place is because this is where the problem lies, the one night college kid party thing.
Which restriction?
I'm sorry, the one to.
7
It's
days.
an owner occupied distinction.
Yeah.
Okay.
And, that kind of dynamic. I will tell you that I spoke to somebody from Airbnb for the first time yesterday, who is an official, I was told something a year ago completely different from Airbnb. A year ago it was, do what you want. We deal with different municipalities all over the country. We'll play ball with whatever it is you guys come up with. The guy I spoke with yesterday was not he wasn't just somebody at corporate headquarters. He works specifically with municipalities on governance, on not restrictions, but
regulations. Regulations?
regulations, thank you. I don't know why I couldn't think of that word. And he said, they're not for this restriction. Although he
The one to
completely.
seven?
This I am.
Yeah, the one to seven. He completely understood why we wanted, but he said that, he thought it was an undue burden on his company.
I think that the 1 to 7 day limitation is to avoid a potential problem. But if it's the case that there aren't any issues, then there are no issues. But if there happen to be issues, then we have the ability, like I said, to revoke their right to use the property for this use. So I think that you can achieve the same thing. You could still stop the bad behavior by just revoking the purpose of it without having to outright ban what could be, not bad behavior. So I think that I, for that reason, am partial to removing to 1 to 7. How do you feel?
No, I understand that, and if the police and the Inspectional Services Department are in constant contact and share information and keep records, and I don't know, is this more than can be expected or handled? I mean, you could tell us, but that's what it's gonna take, because if that doesn't happen, and we're not keeping data on this, we're not gonna know if somebody has 3 infractions or, the only way we do that and somebody's permit gets revoked is if we keep records.
So maybe could we talk about the feasibility of that and whether you think that, we'll actually be able to do that?
So right now, anytime we have a nuisance behavior issue, right, it's from a complaint that stems, right? Police will typically go through their call log and see how many citations have been issued and determine whether or not it meets that criteria. So that communication comes from, like it should, a complaint-based issue, right? And then refers it to us, and then we'll take action, or a combination of the two departments will come up with the next course.
It's sort of a verified complaint basis, right? It's not just somebody calling and complaining, like police
Correct.
take a look at
Right.
it and determine, yeah, there's a problem.
Right. And it has to meet the degree of, standards to what the ordinance is. So there is communication. Is it constant combing through every complaint log? No. But, getting back to the point
I'm
of
just
the
saying
1 to
for a
6
record,
or
yeah.
1 to 7, right? The reason that we're actually doing this is because we will allow somebody right now to have a 7-day rental on a short term, they just have to register it. So the niche I think we're trying to eliminate is that 1 to 6 range. So if we're gonna pass a short-term rental registration, it should be short-term, not, again, what we already have, you're allowed to rent it for a week or more.
I understand that, and I'm agreeing with you if and only if, there's a data capped on, so we can't enforce this law. We don't keep data. It's not possible.
So data is,
So-
yeah, oh, sorry, go ahead.
So we're kind of, to me, one thing leads to the other. If we keep the data, then then there's no reason to have this restriction, because we're going to enforce the law based on the data we keep.
As a clarifying I guess I don't understand why we wouldn't be keeping the data no matter the days. So could you clarify on that?
No, you're right about that. We would be keeping the data either way. But I'm saying I'm more comfortable with
Getting rid of the 7 days.
getting rid of the 7 days, knowing that it's not a matter of that the police write something up, but that there's some kind of mechanism on a given property that we know this property had 3 infractions, 6 months, or whatever it is. Listen, 90-something% are not gonna be a problem. We know that already. It's just when there is a problem, I will tell you, the neighbors of people who have this problem cannot stand this. It can, I hate to be hyperbolic about it, but it can really ruin a person's experience in their neighborhood. So according to the people who have put up with these are the people I want to protect. And if we can protect them by having a uniform standarding, I understand why we would get rid of this restriction, because you're right. If we follow the law and enforce the law, we don't need this restriction.
So I'm just thinking that, I don't want to abort the discussion, but maybe this is one that, can be updated either way, but with just sort of a placeholder note for further discussion by the full council, which, would need to amend it, from the current version. But also that gives the internal team some time or the administrative team, you're all internal. To think through, I'd like to better understand how we do this in the ordinary course, with coordinating with police. And I think we can have further discussion about that to make sure that standard is because it'll be important regardless of the dates. If we're going to say, yes, we're going to allow this activity in the city, where currently it's not specifically provided for, to make sure that what we're saying applies to it is meaningful.
Sharon Petrus?
Yeah, of course.
I would like to add that I think that for this implementation of this short-term rental, that we make no restrictions of less than 7 days. We're already asking a lot of these people to do something that they haven't been doing, and to come in and register and identify themselves. And I was actually on one of the platforms today and just asked for 5 days, 4 days, because that's normally what we use. You got people coming in to go to the clinic, you got people coming in to go to concerts, games. I just think it's too restrictive, so that's my viewpoint on that particular sentence.
And it's good that the staff will have conversations about, ensuring that
Yes.
we're able to enforce it. So one thing to note, so I see that it's 12:15, so I think that we had set aside 2 hours for this meeting, but I know that not everyone has the time. So I guess, how do we are halfway through the document. Do we want to continue to work through?
So we're really not halfway through. We're
Okay.
actually at the end of what our review is, so
Okay.
I think we're like
Oh.
5 minutes from.
Well, close, yeah.
Yeah.
5 minutes, that sounds good.
Okay,
I think it's 5 minutes.
so I guess, so we'll spend the extra 5-10 minutes going through the remainder here, and then, I guess we'll talk about next steps and where we wanna go from here.
Yes.
Okay, so go ahead.
So section 76910, limitations on inspections, we just want to bring to your attention, when we're looking at this a little bit more. The way that this is written is it does seem to indicate that there's an inspection that is required. And so this would be a new inspection that potentially a single family home does not receive. And I don't think that would be our intention. However, we did want to build in, and this is how Dublin handles it, where there's the ability for the administrator to request that inspection.
Section.
So that's just our point there. We'll flush that out a little bit more.
And
This
why
is
would-
the only reference currently to an inspection in the chapter, right?
Right.
So, yeah, it just needs some.
So and what would be the purpose of needing that ability to do that?
There might be a condition that we want to just make sure that the building is in shape to be able to host this short-term rental. It just gives us that ability.
You could receive a complaint from someone who stayed there
Yeah.
as a guest, saying it's not.
I've done
So preserving that.
Those
Not
are-
required.
like that balcony's gonna kill somebody.
Yeah.
Whatever it may be.
Pass-
Okay, okay.
Structural.
No, I get it, I just,
Yeah, structural would be better.
Yeah.
I don't think we want to be like troubleshooting
Electrical
like
issues.
dirty rentals and things like that.
I called about a back balcony. I probably would have done it if I wasn't on council. I could help myself. I was in Baltimore and I toured this guy up. His balcony, his front porch, and electrical socket in the bathroom.
Yeah.
It's like, yeah, someone's gonna kill themselves.
Yeah. And this was a rental?
Mm-hmm.
Okay,
Yeah.
interesting.
And they went in, and they actually found more than I did. So they reached back out, but they said normally they wouldn't have done it because no one typically calls. They just
Yeah.
mark it on the Airbnb site and move on.
And out of curiosity, was it the city that came in or was it?
Baltimore, city of Baltimore.
Okay.
Came and did an inspection after.
I reported a gas leak at a rental one time, but it was the rental company administrator that sent somebody out right away and handled it.
Oh wow.
Yeah.
That's response time.
Heck yeah. Yeah, I was like, wow.
Turned out there was an extra charge for everything, so.
So I'll offer this up to the chair. We can spend some time now on the excise tax and sort of the current thinking on that, or we can finish up with the stuff that we reviewed. That's more substantive to what we're doing.
Okay.
I'll offer that to you. I don't know which.
Yeah, I guess maybe the latter of those two, and then we could tag on like a reminder of what we discussed or what was discussed in the finance committee about the excise tax, if we want.
can I just say one thing about the excise tax and
Yeah.
then we'll go to that. So I spoke, this is again speaking to the
Airbnb.
the Airbnb person. And he said that the way they do it is on their hosting platform, they collect the 3% tax from, and then they distribute it quarterly. And that seems to work if you have the requisite municipal official to receive it. His concern was, don't apply this, please don't apply this, I don't know if he said please, but don't apply this to Airbnb and not to the other platforms.
Oh,
But, and that makes sense. I actually think that's unconstitutional,
yeah.
but to do that, but that was the only thing that,
Yep.
a concern from that vendor.
And I think that's consistent with the current model that's in here. I mean, the expectation would be that the hosting platform would manage the vast majority of that work. There's an obligation placed on the owner to be responsible for it, but in reality, they're gonna satisfy that responsibility by allowing the platform to collect and remit those monies.
Did we say that it has to go through a platform? Because if someone decides to rent on their own and not go through a platform, would they be then responsible for collecting 3%?
You mean directly
That's where
from the
right, like,
host?
so if you list on Craigslist or Facebook Marketplace, whatever, and you're your own private, you don't go through Airbnb or Airbnb, whatever. Are you
So
then?
I know that we
Sorry.
said we talk
I'm
about
sorry.
this later, but I guess Councilwoman Larson, if you wouldn't mind, would you be able to provide a short overview of the Finance Committee and the sort of general consensus against including?
Could I respond to,
Yes.
I apologize,
Yeah.
to the question that was just raised
Sorry.
in terms of definitions
Yeah.
prior to interrupting again. So we define short-term rental in the ordinance as a residential dwelling unit or part offered or held out to the public on a hosting platform
Okay.
through which short-term rentals are listed, advertised, solicited, or otherwise held out. Hosting platform is a person or entity that provides a means through which short-term rentals are offered, listed, advertised, solicited, or otherwise held out for payment or rent, including but not limited to online, virtual, and mobile-based means, mobile apps. So we could tweak that to ensure that those are the mechanisms that are permissible so that,
Because online platform could be Craigslist,
Yeah.
but that's just you as a person, as opposed to an actual,
yeah.
so
I just wanted to point back to that definitional treatment of that question.
But that still doesn't explain how it would happen if they weren't on a platform.
It
Well,
doesn't, and that's what I'm suggesting,
that's what
is
I'm
we
saying, we
might
could
tighten
tweak
that
that
up so
language.
that,
So you couldn't just I couldn't just go ahead and say,
Oh, so would you automatically not be paying the?
No, you would have to, if you're going to do it, you have to use a platform that can do it.
that's specified for it, that's not just you randomly saying.
Oh,
That's the
so you're not
possibility.
allowed to rent if you don't use a platform. Oh, that, now I get it.
Yeah,
Okay.
that would make more sense to me personally.
sorry.
We talked about in the Finance Committee that Cincinnati has a registry for short-term rentals. They currently have 513 units that are registered and they collect $1.671 million for excise tax on those 513 units. Substantially larger city than we are, of course, and we probably wouldn't have that many, but still, per unit, that's a substantial revenue. North Royalton does not have a short-term rental registry and they have one operator and that's $50. So they really are an outlier to what we're trying to get. Rocky River they prohibit short-term rentals. So when we talked about this in Finance Committee, it was decided that as this is something so new to get people to come in and register voluntarily and get involved in the process, that the excise tax was an undue burden that we didn't want to have at this time. But again,
You could revisit it.
if you could revisit it legally down the road.
Sure, which you could adopt it at any time, and the burden that is of concern is on the administration or on owners of
Both.
rental.
For me, it's both the
The-
people that are the hosts, if they have to file those
Sure.
reports and things, and to especially our finance department.
I think on that former point with regard to the owners or short-term renters, operators, most of that again would be handled through the platform.
Right.
So I don't think there's a lot, and the tax is gonna be charged right through to the renter. So I don't think there's gonna be much except a tiny market, adjustment potentially for the operator. The administrative burden internally is a big.
Substantial, yeah.
But since we're discussing this, maybe it's worthwhile, and I'm gonna turn
I'm sorry.
No.
to Alan, because I know we had another thought about how if you don't have the excise tax, then the burden actually falls much more,
On the city.
not on the city,
On the host.
on the host.
Yeah, and I gotta tell you, I don't want that.
You
I
know,
mean,
it's-
I'm going to vote, but
it would all be through the registration or application fee, as opposed to
Yeah.
through this other means, which would be,
The platform just providing us that quarterly
right.
fee for whatever. Right, so now we're chasing down the owner or operator to say, hey, where's your $50 registration? Similar to how we have to chase down occupant certificates for rental registrations on that. So that's a more onerous than just saying, hey, we're gonna charge you $0 for filling this fee out, but there's a whatever percentage excise tax on it that the platform who's running it just provides to us in a quarterly timeframe.
So am I understanding this correctly, that, okay, let's say that we don't include the excise tax. So the owner of the property would fill out the form, maybe pay a fee as specified by the mayor or someone else, maybe $50, something else. And then the property owner would have to pay income tax on the money that they earn. But otherwise, there are no other like fees or taxes associated. Alternatively, what I think that I just heard you say is that we could have the form free and charge the renters, or not renters, but the people who are coming in on a short-term basis, that 3% or something, and the city would get some revenue from that to offset not charging a fee for the form. And then the property owner would still have to pay the income tax on that, but it would be no different from if we did not have the excise tax. Correct. So maybe the excise tax is something that should be considered.
Which is where we ended up that
We don't know.
we keep talking.
And we know the mayor may or may not have
Right.
some thoughts on this.
Councilman?
Just want additional clarification. If we did the excise tax, could you give me a sense of what we could or couldn't use that on? How we could use those funding? Just broadly, and I apologize.
So I think we defined it pretty broadly in that section that we're not yet discussing.
Which page is this on? I'm sorry.
Purpose rate application of sections 161.03, maybe?
And I think it's
Oh, I was right there.
so if you look at, O3B, the excise tax shall provide revenue for the purposes of general municipal operations, procurement of fixed assets, permanent improvements, debt charges, eliminating deficits, and all other lawful purposes. So it really is
Pretty broad.
yeah.
Okay. My mind was just moving.
Oh, sure. And
Once she gave me that number again from Cincinnati, not that it would be that large, I'm like, what could you do? But, okay.
right, it wouldn't be that large, but I mean, Cincinnati's what, 5 times, 6 times Cleveland Heights' size, so a sixth or a fifth or even a tenth of $1.5 million is not nothing.
I think that the understanding should be if we go ahead with this, that the finance department is staffed.
Appropriately.
The money
As needed, yeah.
as needed and the revenue from the excise tax should be directly put in that department as needed. And the excess we can absorb, but I really think staffing the finance department, especially with what they're experiencing right now, is just you have to talk about that.
Yeah, agreed.
What do we charge for landlords for regular rentals right now? Like what's the yearly fee?
So it depends on the dwelling type, but it's 200 per single family, 250 per double, and then it's rated upon unit after that.
And
With the cap, right?
and this legislation proposes no actual fee for short-term rentals?
So it says there's a fee, but it's not in the ordinance. It'll be assigned by whatever policy we decide.
Okay,
But it refers to a fee, but that fee could be anything, right?
I see why we would discuss this later. I'm so sorry, I have to go.
Okay, sounds good. Anything else
Get to
on
it.
the excise tax? Okay,
So just to run through quickly the rest of it, because
Yep.
it's actually not that much more here, so in
Just 2 seconds.
the next section, which is 12, that's the obligations of the platform, and the only thing on here is just, we wanna make sure that they report to us on a very fixed basis. Like, we wanna get all the reports at the same time. It says here quarterly basis, but that could be based on their quarters, not ours, so we're gonna fiddle with that. 13 is now getting into enforcement, suspension, revocation, and penalties. And so I think in sort of our review with other parts of the code, we just wanna make sure that this is in line with that.
Okay.
Because this would be dealing with the registration itself. And the next section is appeals, so it's talking about that process for appeals. As the law director had mentioned, there should be probably an existing board that deals with it. It may be just changed to something else, but yes, absolutely, there should be an appeal process. And then last is the penalty section in 99. That should just mirror how we treat things in chapter 1345. So a lot of this is just, making sure the language is the same, and we just had a little more work.
Okay.
We did not, I should probably say this, but we haven't looked at chapter 161 because we really felt like that was more of a finance discussion, although we do have the opinion that it does impact what that fee may or may not be, but we don't have comments on the sort of text of how that section operates.
So I guess maybe Director Hannah, is his intention to continue to work through that 161?
Let's
Should we
wait till it
break
comes back. I know that the committee meeting that happened did not include the law director, whether he couldn't attend or not. He wasn't part of that conversation, so it was more focused on finance. But I would assume that he would want him to be part of that conversation ultimately.
Okay, so in terms of next steps, so is there additional, I think that there were a few things that you said that the staff was still like working through ideas on. So I'm assuming that we'll need another meeting to continue to like talk through, updates on conversations. How much time do we think that we?
Well, I did want to ask. I think we got clarity on many of the things we wanted to, and there's some additional internal conversation. Ultimately, there's going to need to be a council conversation about this, and I think the law director can say this better than I, but what will eventually need to happen is the ordinance will need to be amended by council. So since it's already an introduced piece of legislation, we are going to give you suggestions, but the council will need to make that. The committee can't even do it. It would have to be the council would have to make it. So I'm wondering if it's better maybe to have that next conversation
With council.
at committee of the whole. Or do we want to do it one more time here?
Well, I just envision us not like actually having everything done by the next conversation, because it seems like, and especially with some of these like excise tax components, it seems like there are, still some outstanding like questions. And so I wouldn't want to, take up the time of committee of the whole if it isn't at a point where we're all like solid with it.
We discussed it in committee. I am not, I can hold another meeting, but we discussed it in committee with ramifications. I think it would behoove us to discuss it, and I've gotten the data, I can go get more data if you want me to from other places, but it seems to me that at this point, we're at a committee of the whole level on the excise tax portion of it.
Okay.
Do we want to burden, not to use that word, do we want to implement this kind of additional revenue collection? And then I would like to have the mayor weigh in on that as well. If he would like to see that as part of the components of this legislation. So you understand what I was saying? Is holding another finance committee meeting, we don't have any new information to negate or to propose.
Right. Yeah, and I certainly understand. Well, I guess, I was thinking about this holistically as a piece of legislation, forgetting that we had left the excise tax component to the finance committee. So if you feel that, we have worked through enough of this now that it would be useful to bring it up during committee of the whole, then, we can certainly do that.
Yeah, I think we still want to do some work behind the scenes.
Okay.
But I'm suggesting that the next time we comments at a committee of the whole.
Okay. Are you thinking, so like the maybe 20th of May? So that's
We could do
that's a few
we could
weeks.
always do a special committee of the whole meeting, particularly just because this is such a,
Can't be
In-depth
squeezed into 15,
piece.
20 minutes.
No.
right.
Yeah.
So I would say that it's probably gonna be more like a special committee of the whole meeting for this particular piece.
How much
With,
additional time are you thinking?
Maybe we can pull the law director back into the conversation.
Labor Day, did you say?
We're talking about, in terms of next steps, maybe the next step being a discussion during a committee of the whole meeting, thinking that we are probably pretty close to being done. And especially since the finance component was removed from this committee's consideration and tossed over to finance where they had enough conversation. Everyone feels. So in terms of timing for a conversation with committee of the whole, we also talked about, maybe having a special committee of the whole meeting because there's so much to discuss here.
I think that probably makes sense, yeah.
Do we think sometime near the end of the month, so maybe like 3-4 weeks away, something like that.
Seems doable. I mean, I think we've had 4 meetings, I think, on it, and I think we made a lot of good progress, and with this discussion now, we've, sort of got a better feel for what the committee at least is thinking council may be looking for. So I would think that we can probably get it to where it's ready for a full committee of the whole discussion
Okay.
by the end of the month.
One other thing, so on the topic of the tax, let's say that we go to committee of the whole, people say, yes, we want to have the excise tax. So in terms of next steps for that component, would the law department need to then look through that section and then
Yeah, and
maybe have more finance committee meetings after starting to look through?
I think so, probably, yeah.
Okay. And then let's say that alternatively, committee of the whole, there's like a sense that they don't want the excise tax. Or do we just scrap out all of that and then there would be no need to send it to the finance committee?
Yeah, that could happen. I mean, I guess if finance wants to, I apologize if you already made a recommendation on it to council. I feel like we've been waiting maybe to report back from both committees. So if it's already been done,
I did read that information into the record.
okay.
Yeah.
But was there a recommendation from the committee? I can't remember.
At the time, we decided that we didn't want to burden the finance department specifically.
Okay.
And at that time, we were talking about what we've learned, that
Okay.
the platforms collect the excise tax.
I just didn't want to cut short finance's process. So if the committee of the whole, to your question, I think wants to entertain some further discussion, they could send it back or they could just do it.
I would prefer to do it that way, actually.
So if our intention is for the next conversation to be during a committee of the whole meeting, should we make a motion during this meeting to send it back?
Sure.
Okay.
No.
We have a motion, second.
I move that after today's extensive discussion, that, and when the staff are ready to have council consider this legislation, that we move it forward to the committee of the whole for the next meeting.
Second.
All in favor?
All in favor?
Aye.
Okay. And did
I'll
we
work on
have an
scheduling.
other topic?
No,
At the end of the agenda?
did we?
You don't have another on here.
Do we not? No.
Okay, so unless there's any other discussion on this legislation, is there? Okay, I'm going to adjourn this meeting. Thank you so much for your time.